Good morning, everyone. Welcome to my channel, UPSC Shorts. Here, I cover the audiobooks of the important books which is used in UPSC by the students. So, here we come up with the most important chapter of the Indian polity. Chapter number 7, Fundamental Rights. The fundamental rights are enshrined in Part 3 of the Constitution from Article 12 to 35. In this regard, the framers of the Constitution derived the inspiration from the Constitution of USA, that is, Bill of Rights. Part 3 of the Constitution is rightly described as Magna Carta of India. It contains a very long and comprehensive list of justiciable fundamental rights. In fact, the fundamental rights in our Constitution are more elaborate than those found in the Constitution of any other country in the world, including USA. The fundamental rights are guaranteed by the Constitution to all persons without any discrimination. They uphold the equality of all individuals, dignity of individual, the larger public interest and the unity of nation. The fundamental rights are meant for promoting the ideal of political democracy. They prevent the establishment of authoritarian and despotic rule in the country and protect the liberties and freedom of the people against invasion by the state. They operate as the limitations on the tyranny of executive and arbitrary laws of the legislature. In short, they aim at establishing a government of laws and not of the men. The fundamental rights are named so because they are guaranteed and protected by the Constitution, which is the fundamental law of the land. They are fundamental also in the sense that they are most essential for all round development, that is, material, intellectual, moral, and spiritual development of all the individuals. Originally, the Constitution has provided 7 fundamental rights, viz. First, right to equality from Article 14 to 18. Second, right to freedom for Article 19 to 22. Third, right against exploitation from Article 23 to 24. Fourth, right to freedom of religion, Article 25 to 28. Fifth, Article cultural and educational rights, Article 29, 30. Sixth, rights to property, Article 31. And seventh, rights to constitutional remedies, Article 32. However, the right to property was deleted from the list of fundamental rights by 44th Amendment Act of 1978. It is made a legal right under Article 300A in Part 12 of the Constitution. So at present, there are only 6 fundamental rights. Features of fundamental rights. The fundamental rights guaranteed by the Constitution are characterized by following. First, some of them are available only to the citizens while others are available to all persons, whether citizens, foreigners or legal persons like corporations and companies. Second, they are not absolute but qualified. The state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is to be decided by the courts. Thus, they strike a balance between rights of individuals and those of the society as a whole, between individual liberty and the social control. Third, all of them are available against the arbitrary action of the state. However, some of them are also available against the action of private individuals. Some of them are negative in character, that is, place limitations on the authority of the state, while others are positive in nature, conferring certain privileges on the persons. Fifth, they are justiciable, allowing persons to move to the courts for their enforcement and if and when they are violated. Sixth, they are defended and guaranteed by the Supreme Court. Hence, the aggrieved person can directly go to the Supreme Court, not necessarily by the way of appeal against the judgment of the High Courts. Seventh, they are not sacrosanct or permanent. The Parliament can curtail or repeal them, but only by a Constitutional Amendment Act and not by the Ordinary Act. Moreover, this can be done without affecting the basic structure of Constitution. The amenability of fundamental rights is explained in detail in chapter number 11. Eighth, they can be suspended during the operation of national emergency except the rights guaranteed under Article 20 and 21. Further, the six guaranteed rights from Article 19 can be suspended only when emergency is declared on the ground of war or external aggression, that is, external emergency, and not on the ground of armed rebellion, that is, internal emergency. The suspension of fundamental rights during the national emergency is explained in detail in chapter number 16. Ninth, the scope of operation is limited by Article 31A, saving of laws providing for the acquisition of estates, etc. Article 31B, validation of certain facts and regulations included in the ninth schedule, and Article 31C, savings of the laws giving effect to the certain directive principles. 10th, their application to the members of armed forces, paramilitary forces, police forces, intelligence agencies, and analogous services can be restricted or abrogated by the Parliament according to Article 33. 11th, their application can be restricted while martial law is in force in any area. Martial law means military rule imposed under the abnormal circumstances to restore order. According to Article 34, it is different from the imposition of national emergency. 12. Most of them are directly enforceable, that is self-executory, while a few of them can be enforced on the basis of a law made for the giving effect to them. Such laws can be made only by the Parliament and not by the state legislature, so that the uniformity throughout the country is maintained. Article 35. Definition of state. The term state has been used in different provisions concerning the fundamental rights. Hence, the Article 12 has defined the term for the purposes of Part 3. According to it, the state includes following: Government and the Parliament of India, that is, executive and the legislative organs of the Union Government. Government and the legislature of state, that is, executive and legislative organ of the state governments. All local authorities, that is, municipalities, panchayats, district boards, improvement trust, etc. All other authorities, that is, statutory or non-statutory authorities like LIC, ONGC, SEL, etc. Thus, the state has defined in a wider sense so as to include all its agencies. It is the actions of these agencies that can be challenged in the courts as violating the fundamental rights. According to Supreme Court, even a private body or an agency working as an instrument of the state falls within the means of the state under Article 12. Laws inconsistent with the fundamental rights. Article 13 declares that all laws that are inconsistent with the inconsistent or in the derogation of any of the fundamental rights shall be void. In other words, it expressly provides for the doctrine of judicial review. This power has been confirmed on the Supreme Court under Article 32 and the High Courts under Article 226 that can declare a law unconstitutional and invalid on the ground of contravention of any fundamental rights. The term law in the Article 13 has been given a wide connotation so as to include the following: A. Permanent laws enacted by the Parliament or the state legislature. B. Temporary laws like ordinances issued by the President of the state or the state governors. C. Statutory instruments in the nature of delegated legislation, that is, executive legislation like orders, bylaws, rules, regulation, and notification. And D. Non-legislative sources of laws, that is, custom or usage of having force of law. Thus, not only the legislation but any of the above can be challenged in the courts as violating a fundamental right and hence can be declared as void. Further, Article 13 declares that the constitutional amendment is not a law and hence cannot be challenged. However, the Supreme Court held in the Kesavananda Bharti case in 1973 that the constitutional amendment can be challenged on the ground that it violates the fundamental rights that forms a part of the basic structure of the Constitution and hence can be declared as void. You can check the fundamental rights at glance from table number 7.1. Rights to equality. First, equality before the law and equal protection of laws. Article 14 says that the state shall not deny any person equality before law or equal protection of the laws within the territory of India. This provision confers rights on the all persons, whether citizens or foreigners. Moreover, the word person includes legal person, which the statutory corporations, companies, registered societies, or any other type of legal person. The concept of equality before law is the British in origin, while the concept of equal protection of laws has been taken from the American Constitution. The first concept connotes the absence of any special privileges in the favor of any person, the equal subjection of all persons to the ordinary law of land administered by ordinary law of courts, and no person, whether rich or poor, high or low, official or non official, is above the law. The second concept, on the other hand, connotes the equality of the treatment under the equal circumstances, both in the privileges conferred and the liabilities imposed by the law. The similar application of the same laws to all persons who are similarly situated and like should be treated alike without any discrimination. Thus, the former is a negative concept while latter is a positive concept. However, both of them aim at establishing the equality of legal status, opportunity, and justice. The Supreme Court held that where equals and unequals are treated differently, Article 14 does not apply. While Article 14 forbids the class legislation, it permits reasonable classification of persons, objects, and transactions by law. But the classification should not be arbitrary, artificial, or evasive. Rather, it should be based on the intelligible, intelligible Rather, it should be based on intelligible, differential, and substantial distinction. Rule of law. The concept of equality before law is an element of the concept of rule of law propounded by A.V. Dicey, the British jurist. His concept has the following three elements or aspects. First, absence of arbitrary power. That is, no man can be punished except for the breach of law. Second, the equality before law, that is, equal subjection of all citizens, rich or poor, high or low, official or unofficial, to the ordinary law of the land administered by the ordinary law courts. And third, the primacy of the rights of individual, that is, the Constitution is the best result of the rights of individuals as defined and enforced by the courts of law rather than the Constitution being the source of individual rights. The first and the second elements are applicable in the Indian system and not the third one. In Indian system, the Constitution is the source of individual rights. The Supreme Court held that the rule of law embodies Article 14 is a basic structure of the Constitution, and hence it cannot be destroyed by even any of the amendment. Exceptions to the equality. The rule of equality before law is not absolute, and there is constitutional and other exceptional to it. These are mentioned below. First, the President of India and the Governor of States enjoy following immunities according to Article 361. The President and Governor is not answerable to any court the exercise and performance of the powers and duties of the office. No criminal proceedings shall be instituted or continued against the President or the Governor in any court during his term of the office. No process for the arrest or imprisonment of the President or Governor shall be issued from any court during his term of office. No civil proceeding against the President or the Governor should be instituted during the term of office in any court in respect of any act done by him in his personal capacity, whether before or after he entered upon his office, until the expiration of the 2 months of notice and after the notice has been delivered to him. Second, no person shall be liable to any civil or criminal proceeding in any court in respect to the publication in a newspaper or by radio or television of substantially true report of any proceeding of either House of the Parliament or the House of Legislature of the state, according to Article 361A. Third, no member of the Parliament shall be liable to any proceeding in any court in respect of anything said or any vote given by him in the Parliament or any committee thereof, according to Article 105. Fourth, no member of the legislature of a state shall be liable to any proceeding in any court in respect of anything said or any vote given by him in the legislature or any committee thereof, according to Article 194. Fifth, Article 31C is an exception to Article 14. It provides that the laws made by state for implementing the directive principles contained in Clause B or Clause C of the Article 39 cannot be challenged on the ground that they are violative of Article 14. The Supreme Court held that where Article 31C comes in, Article 14 goes out. Sixth, the foreign sovereign rulers, ambassadors, and diplomats enjoy the immunity from criminal and civil proceedings. Seventh, the UNO and its agencies enjoy the diplomatic immunity. Second, the prohibition of discrimination on certain grounds. Article 15 provides that the state shall not discriminate any citizen on the grounds only of the religion, race, caste, sex, or place of birth. The two crucial words in this provision are discrimination, and the only word discrimination means to make the adverse distinction with regard to or distinguish unfavorably from others. The use of the word only connotes that the discrimination on other grounds is not prohibited. The second provision of Article 15 says that no citizen shall be subjected to any disability, liability, restriction, or condition on the grounds only on the religion, race, caste, sex, or place of birth with regard to access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, gatherings, ghats, roads, and the places of public resort maintained wholly or partially by the state funds or dedicated to the use of general public. This provision prohibits the discrimination both by state and private individuals, while the former provision prohibits the discrimination only by the state. There are four exceptions to this general rule of non-discrimination. A. The state is permitted to make any special provision for women and children. For example, reservation for the women in the local bodies or the provision of free education for the children. B. The state is permitted to make any special provision for the advancement of any socially, educationally backward classes of the citizens or for the scheduled caste and scheduled tribes. For example, the reservation of seats or the fee concessions in the public educational institutions. C. The state is empowered to make any special provision for the advancement of the socially and educationally backward classes of the citizens or for the scheduled caste or the scheduled tribes regarding their admission to the educational institutions, including the private educational institution, whether aided or unaided by the state, except the minority educational institution. D. The state is empowered to make any special provision for the advancement of any economically weaker section of the citizens. Further, the state is allowed to make a provision for the reservation up to 10% of the seats for such sections in admission to the educational institutions, including private educational institutions, whether aided or unaided by states, except the minority educational institutions. This reservation up to 10% would be in addition to the existing reservation for this purpose. The economically weaker sections would be notified by the state from time to time on the basis of the family income and other indicators of the economic disadvantage. Reservation for OBC in educational institutions. The above exceptions was added by 93rd Amendment Act of 2005. In order to give effect to this provision, the Centre enacted the Central Educational Institutions Reservation in Admission Act 2006, providing a quota of 27% for the candidates belonging to the other backward classes in all central higher educational institutions, including the Indian Institute of Technology (IITs) on the Indian Institute of Management (IIMs). The April 2008 and Supreme Court upheld the validity of both the Amendment Act and the OBC Quota Act, but the court directed that the central government to exclude the creamy layer, that is the advanced sections among the OBC, while implementing the law. The children of the following different categories of the people belong to the creamy layer among the OBCs and thus will not get the quota benefit. First, persons holding constitutional posts like President, Vice President, judges of Supreme Court and High Courts, chairmen and members of UPSC, SPSC, CEC, CHE, and so on. Second, Group A, Class 1, Group B, Class 2, officers of the All India Central and State Services and the employees holding equivalent posts in PSUs, bank, insurance organizations, universities, etc., and also in the private employment. Third, the persons who are in the rank of colonel or above in the army and equivalent post in the navy or the air force and the paramilitary forces. Fourth, professionals like doctors, lawyers, engineers, artists, authors, consultants, and so on. Fifth, persons engaged in a trade, business, and industry. Sixth, people holding agricultural land above certain limit and the vacant land or building in urban areas. Seventh, persons having gross annual income of more than 8 lakh or possessing the wealth above the exemption limit. In 1993, when the creamy layer ceiling was introduced, it was 1 lakh. It was subsequently revised to 2.5 lakh in 2004, 4.5 lakh in 2008, 6 lakh in 2013, and 8 lakh in 2017. Reservation for the EWS in educational institutions. The above exception D was added by 103rd Amendment Act of 2019. In order to give effect to this provision, the central government issued an order in 2019 providing the 10% reservation to the economically weaker sections in the admission to educational institutions. The benefit of these reservations can be availed by persons belonging to the EWS who are not covered under any of the existing schemes or of the reservations for SCs, STs, and OBCs. The eligibility criteria laid down in this regard is as follows. First, the person whose family has gross annual income below 8 lakh rupees has been identified as EWS for the benefit of the reservation. The income would include income from all sources like salary, agriculture, business, profession, etc. And it would be the income for the financial year prior to the year of application. Second, persons whose family owns or possesses any of the following assets are to be excluded from being identified as EWS irrespective of the family income. A. 5 acres of agricultural land and above. B. Residential flat of 1000 square feet and above. C. Residential plot of 100 square yards and above in the notified municipalities. D. Residential plot of 200 square yards and above in any other areas than notified municipalities. Third, the property held by a family in different locations or different places, cities would be clubbed while applying the land or the property holding test to determine the EWS status. Fourth, the family for this purpose would include the person who seeks the benefit for reservation, his or her parents and siblings below the age of 18, as also his her spouse and the children below the age of 18. Third, equality of opportunity in the public employment. Article 16 provides for the equality of opportunity in the for the all citizens in the matters of public employment or employment to any office under the state. No citizen can be discriminated against or ineligible for any of the employment or the office under the state on the grounds of only religion, race, caste, sex, descent, place of birth, or residence. There are four exceptions to this general rule of equality of opportunity in the public employment. A. Parliament can prescribe the residence as a condition for certain employment or the appointment in a state or union territory or local authority or other authority as the public employment requirement as to Residence Act of 1957, which is expired in 1974. There is no such provision for any state except Andhra Pradesh and Telangana. B. The state can provide reservation of appointments in favor of any backward class that is not adequately represented in the state services. A law can provide that the incumbent of an office related to the religious or denominational institution of a member of its governing body should belong to the particular religion or denomination. D. The state is permitted to make the provisions of reservation up to 10% of the appointments or the posts in favor of any economically weaker sections of the citizen. This reservation of up to 10% would be in addition to the existing reservation. For this purpose, the economically weaker section would be notified by the state from time to time on the basis of family income and other indicators of the economic disadvantage. Mandal Commission and Aftermath. In 1979, the Morarji Desai government appointed the second backward classes commissions under the chairmanship of B.P. Mandal, a member of parliament in terms of Article 340 of the Constitution, to investigate the conditions of socially and educationally backward commission and submitted its reports in 1980 and identified as many as 3,743 castes as socially and economically backward classes, but they constitute nearly 52% component of the population, excluding the scheduled caste and the scheduled tribes. The Commission recommended for 27% of reservation in government jobs for the other backward classes, OBCs, so that the total reservation for all STs, and OBCs amounts to 50%. It was after 10 years, in 1990, that the VP Singh government declared a reservation of 27% government jobs for the OBCs. Again, in 1991, the Narasimha Rao government introduced two changes. First, the preference to the poorer section among the OBCs in 27% quota, that is, the adoption of economic criteria in granting the reservation. And second, the reservation of another 10% of the jobs for poorer, that is, economically backward sector of the higher caste who do not cover in the existing schemes of the reservation. In the famous Mandal case of 1992, the scope and the extent of Article 16, the fourth clause, which provides for the reservation of the jobs in favor of the backward classes, has been examined thoroughly by the Supreme Court, though the court has rejected the additional
Reservation of 10% for the poorer sections of the higher caste, it upheld the constitutional validity of 27% reservation for the OBC with certain conditions that are the advanced sections among the OBCs, that is the creamy layer, should be excluded from the list of beneficiaries of the reservation. No reservation in promotions. Reservation should be confined to the initial appointments only. Any existing reservation in the promotion can continue for the 5 years only, that is up to 1997. The total reserved quota should not exceed 50% except in some extraordinary situations. This rule should be applied every year. The carry forward rule in case of unfilled, that is backlog vacancies, is valid, but it should not violate the 50% rule. A permanent statutory body should be established to examine the complaints of over inclusion and under inclusion in the list of OBCs. With regard to the above rulings of Supreme Court, the government has taken the following actions. A. Ramanandan Committee was appointed to identify the creamy layer among the OBCs. It submitted its report in 1993, which was accepted. B. National Commission for Backward Classes was established in 1993 by the Act of Parliament. Its mandate was to examine the complaints of under-inclusion, over-inclusion or non-inclusion of any classes of citizen in the list of backward classes for the purpose of job reservation. Later, 102nd Amendment Act of 2018 conferred a constitutional status for the Commission and also enlarged its functions. For this purpose, the amendment inserted a new article, Article 338B in the Constitution. C. In order to nullify the ruling with the regard to reservation in promotions, the 77th Amendment Act was enacted in 1995. It added a new provision in Article 16 that empowers the state to provide for the reservations in promotions of any services under the state in favor of SCs, STs that are not adequately represented in the state services. Again, the 85th Amendment Act of 2001 provides for the consequential seniority in the case of promotion by virtue of rule of reservation for the government servants belonging to the SCs and STs with retrospective effect from June 1995. D. The ruling with regard to the backlog of vacancies was nullified by 81st Amendment Act of 2000. It added another new provision in Article 16 that empowers to the state to consider the unfilled reserve vacancies for a year as a separate class of vacancies to be filled up in any succeeding year or years. Such class of vacancies are not to be combined up with the vacancies of the year in which they are being filled up to determine the ceiling of 50% reservation on the total number of vacancies of that year. In brief, it ends the 50% ceiling on the reservation in the backlog vacancies. E. The 76th Amendment Acts of 1994 had placed the Tamil Nadu Reservation Act of 1994 in the ninth schedule to protect it from the judicial review, as it provided for the 69% of the reservation, far exceeding the 50% ceiling. Reservation of EWS in the public employment. The above exception D was added by 103rd Amendment Act of 2019 in order to give effect to this provision. The central government issued an order in 2019 providing the 10% of reservation to the economically weaker section in the civil post and the reservations in the government of India. The benefit of this reservation can be availed by the persons belonging to the EWS who are not covered under any of the existing schemes of the reservation for SCs, STs and OBCs. The eligibility criteria laid down in this regard has already been explained under Article 15. Further, the scientific and technical posts which satisfy all the following conditions can be exempted from the purview of this reservation. First, the post should be in the grades above or lower grades in Group A of the service concerned. They should be classified as a scientific or technical in the norms of Cabinet Secretariat Order under 1961, according to which scientific and technical posts for which the qualification in the natural sciences or exact sciences or the applied sciences or in technology are prescribed and incumbents of which have to use that knowledge in discharge of their duties. And third, the post should be conducting research or for organizing and guiding and directing the research. Thank you. Here we complete with the part 1 of fundamental rights. In second part we will continue from the abolition of untouchability. Thank you. Have a good day.